Hello, everyone. Welcome. It's nice to see so many familiar names, and I want to get to know everyone who's joining us. So please, in the chat box, let us know your name, your pronouns, and where you're joining us from. And we're going to get started in about a minute or so. So in the meantime, let's build community together. We're also going to be having a Q&A at the end. So if you have initial questions or just comments for the panelists, let us know in the comments section. And I see a lot of folks from the Uncommon Law family here, so welcome. And I also see a lot of ChangeLawyers folks, so welcome to all of our families coming together for this event. And like I said, we're just going to give folks about another minute to join or so. Hi, Brittany. Welcome. Joining us from Illinois. Great. Student. Hi, Susan. Joining us from Stanford Law 3 Strikes Project. It's going to be a very activist crowd, which if you all have been to our events before, you know that that's who our folks are. Hi, welcome, Family Defenders, Michelle Gomez. Jenny, welcome. Bri. We have Oakland and San Francisco folks in the room. All right, folks, so let's go ahead and get started. I'm gonna introduce our panelists, but in the meantime, you know, it's really important for us, for you all to build community in the next hour. Times are tough and moments like this are super important during these times. So get to know each other, find your people in the comment section, let us know who you are, your pronouns, and where you're coming from. And we will circle back with you at the end for the Q&A part. So let's officially start. For those of you who do not know me, my name is Carlos. I am the Chief Content Director at ChangeLawyers, and welcome to Race as a Proxy for Risk. This is the second part in a 3-part special event series between my organization, ChangeLawyers, and Uncommon Law. And for those of you who don't know ChangeLawyers, we are a foundation, we're a legal foundation, and we fund the next generation of lawyers and activists. Before we begin today, I do want to acknowledge that there's most likely a mix of emotions in the room. Last week, if you all joined us for part 1 of this series, as we were talking about mass incarceration and the legacy of slavery, Keith and Zach were up here talking about all of that. The Derek Chauvin verdict was being announced in real time. And it was really emotional, and it was very highly charged for a lot of us. And I do want to make one thing clear, though, to sort of set the tone for the next hour. Derek Chauvin being rightfully convicted of murdering George Floyd isn't justice, at least not in the eyes of ChangeLawyers. It's just accountability. Justice would be if George were still here to be able to hold his daughter. And so with this mix of emotions, I want to just put out good intentions into the room. I'm grateful for all of you. I'm grateful that we have the next hour to make space and show up and talk and build power together. With this in mind, we will be talking about issues that primarily affect BIPOC folks. And so we're going to center these voices in the next room. We're going to center identities, racial and otherwise, and we're going to center emotions and vulnerability. So we invite you all to share a little bit about yourself in the comments section if you're comfortable with that. But do keep in mind that if you are not BIPOC, just be mindful of how much space you take in the chat box. So with that in mind, I want to introduce our folks today, starting off with Keith from Uncommon Law. For those of you who do not know him, you should definitely get to know him. Keith is an amazing advocate and lawyer who's been doing this work for over 20 years. He's the founder and leader of Uncommon Law. And they are an organization that ChangeLawyers really holds very closely for their transformative work in trying to redefine what it means to bring people home from prison. In 2018, Keith was selected as one of the Obama Foundation's inaugural fellows, and he's been recognized recently by the James Irvine Foundation with their Leadership Award. So welcome, Keith. Nice to see you.
Hello, Carlos. Thank you. Nice to see you too.
I'm also going to introduce Nicole D. Porter, who manages the Sentencing Project's state and local advocacy efforts on everything from sentencing reform to voting rights to eliminating racial disparities in the criminal justice system. So basically everything that's in the news right now, Nicole is doing. And so Nicole has been honored in so many ways, but one of the coolest, I think, is she was named by Essence Magazine as one of the new civil rights leaders for her work in trying to eliminate and dismantle mass incarceration. So welcome, Nicole. Really, really happy to have you and your organization represented here.
Glad to be joining you all this afternoon. Thanks for having me.
And I am also going to introduce Emile de Weaver. Emile has an incredible story, and I think that his perspective in particular is going to add a lot to the conversation today. So Emile is a fellow at Impact Justice. He's a Black community organizer. He's a literary writer, a journalist, and the co-founder of PrisonRenaissance.org, which he co-founded while he was serving a 67-year life sentence in prison. His sentence was commuted by Governor Jerry Brown in 2017. And right now, in addition to being a fellow at Impact Justice, Emile is also working full-time as a product specialist for Pilot.com and also as a guest lecturer and freelance writer. So it is my honor to welcome Emile to the conversation.
Hi, Carlos. How you doing? Thanks for having me here.
Thank you for coming. And Keith, I'm done. I'll let you take it over.
All right. Well, I first want to say I'm really honored to be speaking with both of you today, and I'll note for Carlos that Emile's got some updates, I think, to his sort of bio. He's been a busy man, and a lot. And I'm sure hopefully he'll be able to update us with some of that. I personally do know that he considers himself he's a formerly incarcerated writer and activist and senior strategist now with the Prison Policy Initiative. He's proudly displaying his shirt there, and hopefully he'll be able to talk to us about that work. But the only other thing, Carlos, that you mentioned, and discussing very briefly the Chauvin verdict. I heard you use the word accountability. I don't think we've got that, but we do have a guilty verdict. We don't know whether accountability will ever happen, but I look forward to having that kind of conversation as well. Today, we're really, we call this talk race as a proxy for risk. We're really focusing on the idea of discretionary parole. And so that covers the decision that really results in the release for some people, for a lot of people, thousands and thousands of people, they're released from prison. We're talking about a population of people who are serving life sentences who will not be released unless and until a parole board, or in some cases a governor, says it's safe to do so. This is a type of sentence that it's different from those that are of a fixed duration. For people who are sentenced to 5 or 10 years in prison, they are automatically released when that period expires. Often even before that, if they earn sort of credit towards that. But for people serving life sentences with the possibility of parole, they serve a certain minimum number of years, 7 years, 15 years, 25 years, before they become eligible to be considered for parole. And when they are considered, they have to convince a parole board. In California, these folks are appointed by the governor. They have to convince them that they have changed their lives enough so they can safely be released. So these are parole commissioners who are deciding whether or not the person before them presents an unreasonable risk to public safety. Nationwide, there are more than 200,000 people serving these sentences. In California, we have more than 35,000 of them, 35,000. And as we get into this issue of what these sentences look like, and as we apply this lens of what's the racial aspect of this, what are the racial implications, we'll talk a little bit about some of the data. There's not nearly enough that's available. There was a study a couple years ago by a law professor, her name is Kristen Bell, where she reviewed hundreds of parole hearing transcripts. And she found, among other things, that Black parole applicants were 3 times less likely to be granted parole when compared to non-Black parole applicants. There's some more recent data that was analyzed by Michael Brodheim, Mr. Brodheim is someone who was doing research and litigation even while serving a life sentence himself. And he found that Black parole applicants are granted parole at the lowest rate of all racial groups. And this is looking at California data under both Governor Brown and Governor Newsom. That fact remains the same, even under Governor Newsom. He also found that Blacks are much less likely to be granted parole when the commissioner is white compared to when the commissioner is of any other race. In other words, race matters in these proceedings. It shouldn't be a surprise based on the fact that we know race matters everywhere else in this country. I look forward to doing a show at some point with Mr. Brodheim so he can share his work with us. I think one of the important pieces of his work is that he had to sue the state of California, the parole board and Department of Corrections for years just to get a court order to make them give him the race data. They wouldn't even give it to him. And I personally wish that we had prison and parole officials who were willing to tackle these issues head on rather than pretend that everything's fine and to not even look at this troubling data. So with that, we're looking at race. We're looking at the discretionary parole process. And I'm gonna start with you, Emil, if that's okay. Having been sentenced to life in prison with the possibility of parole, I'm wondering how hopeful you were that you would ever be released. And then what was your sense about what you would need to do in order to be released? And I suspect that may be something that sort of evolved from the time you first got to prison to years later when you were approaching the parole board. Can you talk a little bit about that process for you?
Yeah, I mean, I think it's important to set a little context, right? And I think that when we're talking about criminal justice and we're talking about like white supremacy in America, we need to acknowledge that there's always a story of what's happening, and then there's actually what's happening. And that's like a duality that's going to exist in this struggle until we get better at doing better. And so you mentioned that like I had life with the possibility of parole, and that's the story. But the reality is there was no possibility of my parole. Number one, I had been sentenced to 67 years to life when I was 18 years old. So I was expected to die in prison. Number two, when I was sentenced to 67 to life, and the way that the political landscape was in California, Hugo Pinnell was serving like his 28th year in prison on a 7-year to life sentence. Sandra Davis Lawrence was serving her 21st year in prison on a 7 to life sentence she got in 1978. So to answer your question, for me, there was no possibility of parole when I, a poor Black high school dropout, was sentenced to 67 years to life. I mean, human beings are very resilient. And so like, you know, we need to figure out how to go on. And so how I figured out how to go on was I convinced myself that I didn't know how I was going to get out of prison, but I was going to find a way out of prison. I dedicated my life to getting out of prison. At the time, I told myself I'm going to write my way out of prison. And that was just a project I worked on for about 15 years, which is how long it took for the political landscape to start to shift a little bit, where there did become like cracks in the door, and there were like opportunities and possibilities to get out. And I speak particularly of the passage of Senate Bills 260 and 261, which made it so that like people who were sentenced to these extraordinary sentences before they were 25 could get a parole hearing after 20 or 25 years.
And so you had this with these Senate bills you just mentioned. How did that impact your, I don't know if it's the attitude towards the parole board, but certainly your prospects for release were improved. But I'm specifically interested in your thinking of what it would then take to get through this process. What was your thinking when you saw, oh, I'm going to get a chance to go to the parole board soon?
I mean, because I had been like I think that my story, like I had been assuming that I was going to be able to come up before someone at some point that was undefined in my life and have a chance to go home. So I had been preparing for the last 20 years. And before it was clearly defined as a parole board, what I was doing was like just creating a professional life for myself, creating networks, trying to generate capital so I could have something to come home to. But once it became clear that you can go to the parole board, I started attending more groups. I was already in groups, but I started attending more groups because I understood that the language that the parole board requires to grant its very low grant rate was something that you learned in these groups. And so I started going to a lot of the rehabilitation self-help groups and preparing for board, rather than some kind of like before, just like I'm preparing for anything. When it became clear that you can prepare for board, I started to prepare for board.
Right. Well, you mentioned the very low parole grant rates, and really for the last 40 years in California, at least, while the statute that governs this process mandates that parole grants are supposed to be the norm, in reality, only 16% of the scheduled parole hearings have resulted in parole grants. And that was true even last year, at the height of the pandemic, when we should be finding ways to release people, especially people who are older and sicker, and people who present the lowest risks to public safety. We still, in California at least, had only 16% of the scheduled hearings result in parole grants. And to take a step back, we're in a country that has spent its entire history making all of us believe that Black people are inherently violent and dangerous. And this goes for our kids too, right? And as a result, we're more likely to be stopped without just cause by police, more likely to be arrested at school, to have force used against us, to be killed by police, to be charged with and convicted of crimes carrying longer sentences, more likely to be incarcerated, more likely to be denied bail. And once we get to prison, Black folks are more likely to receive rule violation reports and to be housed in higher security level prisons. And when you look at the issue of the discretionary parole decision on the back end of all of that, we see that Black people make up almost half of the people serving life sentences nationally. I talked a little bit about some preliminary data on California's racial disparities in parole hearing outcomes. Nicole, I want to turn to you because I often turn to the Sentencing Project when I'm trying to figure out what the actual data is on parole hearings and other sentencing issues for sure. Can you talk about how difficult it has been to obtain race data when it comes to parole hearing outcomes and what the limited data is telling us?
Yeah, well, thank you for the question, and thank you for including me in the conversation. Emil, it's exciting to see your new role at Prison Policy Initiative. So I want to definitely talk to you more about that offline. And congrats on that, by the way.
Thank you.
So Keith, to your question though, the reality is that there is an underdeveloped analysis on what the outcomes are in terms of racial disparity for discretionary parole hearings. In preparing for this conversation, I reacquainted myself with information out of New York that's a couple of years old. And as far as I'm aware, This is one of the only sort of public accounts of racial disparity outcomes on discretionary parole hearings, because New York also has a sizable parole eligible lifer population. And the New York Times a few years ago was looking at outcomes in discretionary parole hearings for life sentence individuals. And so in an analysis from 2018 to 2020, there was a disproportionate, Blacks were underrepresented in parole releases for parole eligible individuals. Of the folks who were released, who are eligible for release from October 2018 through October 2020, 41% were white, compared to 34% who are Black and 33% who are Latinx. And, you know, this is an underrepresentation of the number of African Americans and Latinx folks who are sentenced to parole eligible life sentence in New York. Nationally, 1 out of every 20 Black men in prison is in prison on a life prison term. So that's 20% of the entire prison population. And so of, you know, total people serving time inside. So this analysis, you know, similar conversations need to happen in other states where there's discretionary parole for life sentence individuals. And I'm curious, in California, it's, you know, interesting that there's been an effort to get this information from your parole board, that there's been a need to sue the parole board in order to obtain the information. And then there's going to be an ongoing need to disclose that information, do regular reports out of racial disparity and, you know, demographic outcomes of parole eligible releases, and, you know, people who go before discretionary parole hearings. I just say that anywhere in the system where there's bias, anywhere in the system where there's discretion, there is implicit bias, if not explicit bias, and if not, the need to include practices and policies that will help counter any implicit, if not explicit, biases that disadvantage Black and Latinx and other BIPOC individuals who, you know, receive any discretionary review, whether or not it's for parole or any other review, including when a governor, and your governors in particular, use of their authority on commutations and clemency petitions. So any point in the system where there's discretion, and, you know, nationally, this conversation happens way before we get to discretionary parole hearings, but certainly in the context of discretionary parole, operationalizing and normalizing practices that help counter any implicit or explicit bias is what's needed. And it's hard to uncover this because people haven't been looking at this. You know, much of the movement at this point is really expanding parole eligibility. The Sentencing Project launched a campaign at the end of 2018, the Campaign to End Life Imprisonment, that talks about the problems of the growth of life imprisonment. We have more people sentenced to life in prison today than were actually in prison total in 1970 at the national level. And that's true in almost half the states, including California. So there's such a focus in that part of the effort to challenge mass incarceration to expand parole eligibility, that shining a light on the racially disparate outcomes for people who are currently eligible for parole releases is an explored strategy and underexplored need in challenging mass incarceration. Although clearly it's right there, it's front and present to why we have to end life imprisonment outright and open up authentic, genuine opportunities for release and provide the remedies for release for people who have currently been disappeared to life imprisonment and mass imprisonment in general.
Thank you. Thank you. I mean, it seems to be in most places, certainly here in California, a willful ignorance of the facts about the role that race plays in our parole hearings. I mentioned Dr. Kristen Bell's work. Her study is called A Stone of Hope. And it was actually a review of several hundred parole hearing transcripts that were intended to reflect the parole board's new approach to considering the possibility for releasing those who were sentenced in their youth. People who were under 18 when they received their life sentences were entitled under Senate Bill 260 to have a special kind of parole hearing at which their youth was supposed to be considered. There's supposed to be a greater expectation that they would be released. So the fact that she found that people who were Black were much less likely to be granted parole was a huge concern. I mean, overall, their parole grant rates for young people receiving life sentences were not any different than everyone else who was going to the parole board. But the fact that she was able to identify that the race of the parole applicant was a major factor. And then you had, not only did the parole board not say, we're concerned about that, we should learn more about that, we should do our own study to figure out beyond these 300-400 cases, how widespread is this issue? Should we retrain our commissioners? How should we change the criteria by which we conduct these proceedings? They didn't do any of that. Instead, they fought for 2 years to not release any race data because they didn't want a bigger study to be done. They did they not do their own study, they thwarted efforts of research to do further study. Fortunately, as I mentioned, Mr. Brodheim and others and Dr. Bell went back and sued to get more data to tell a fuller story. So I'm curious now, for the sort of the experience of this process and get your perspective here, Emil. I'm wondering about your thoughts about whether the way that people are expected to show up at the parole hearings lends itself to the same kind of biases we see at other stages in our criminal legal process.
I mean, I would say absolutely it does, and like a couple quick examples of like what my impression of what it takes to show up at board. When I went to board several years ago, and I have a group of friends, and like we all did very well at board, and when we hang around people, often what they jokingly say is like, "Wow, you guys should be therapists." And I think that is that's hyperbolic, but I think that comes very close to the standard of what like the board wants to see when you come into a boardroom. And what that means in practical terms is they are looking for people who are articulate, if not hyper articulate. They are looking for people who translate to white culture very well. They are looking for people who legitimate the state practice of mass incarceration and take on responsibility of the state's like bad policies and be like, yeah, these policies are just and I deserve to be in this situation. And I think like a really striking example of how that plays out comes with this 70-year-old man that I knew in a group once, and he was talking about his experiences at board, and he was talking about how he kept getting denied. And he had the knowledge that he was getting denied because he had a thick Southern accent that in California is very much associated with not being educated. And so he had enough awareness to understand what was happening, that he wasn't articulate enough to meet the board's muster. And he had this accent that he could do nothing about. So he was this man telling this story, and it was just heartbreaking because he was like, I can't change the way I speak. I've taken all of the programs. I'm 70 years old. I'm not committing any more crimes. And I can't get out because of the way I sound. And what that translates into is he couldn't get out because he was a Southern Black man. He couldn't get out because he couldn't present in a way that makes white people in white culture feel comfortable, which is generally presenting as like, they expect a white male to present. By contrast, I did very well in board because I'm a professional writer, and so I'm hyper articulate, and I know how to translate. And all of this plays into the biases surrounding race that already exist in the criminal justice system.
I'm reminded of a time a few years ago when I was in a parole hearing, and the client was doing a great job laying out his story, and at one point one of the commissioners commented, "Oh, you sound so articulate," which we all know what that means.
We all have stories about that.
And I just couldn't resist. I said, Commissioner, let me explain something to you, what that means when you say that. And I took a minute or two and shared my perspective on how that's actually offensive, what she thinks she intends as a compliment. And at the end of the hearing, she actually granted that person parole, and she said that in my closing, I too sounded articulate. But there are a lot of moments that I've had where I see that a big part of my role as the attorney and advocate is to help the commissioners understand who my client is, to help them be able to move all the other things out of the way for them to be able to hear and see the client for themselves. But I mean, the experience is exactly what you pointed to, Emil, that if people don't present in a certain way or have someone to help sort of create that filter for the parole board, they're stuck. And I actually have the same question for you, Nicole, if you have thoughts about whether there's something about the way people show up in their hearings that lends itself to those same biases that we've been talking about at every other stage in the criminal legal process.
Well, I mean, I think the practice has been to operationalize practices with the goal to reduce implicit, if not explicit, bias in these discretionary hearings for parole at the back end of someone's imprisonment experience, and then at sentencing during the pretrial phase and sentencing phase for people on the front end. The challenges of how to do that. So at the Sentencing Project, there's one aspect of our policymaking recommendations around racial impact statements, which we encourage, and the adoption and development of proposed sentencing laws. So that is at the legislative phase in trying to address the racism and the bias of lawmakers in developing, proposed ways to disappear people because of who they imagine to be, that they're, trying to disappear and lock up. But the big picture for racial impact statements is that it wouldn't just be within legislation, it would also be in other points of discretion in the criminal legal process, including possibly for discretionary parole hearings, or for a meta conversation amongst a parole board to operationalize decision-making points for parole board members to sort of shift standards and shift the practices in a review process to try to get at some of the implicit and explicit biases that might undermine or disadvantage a Black or Brown or other BIPOC residents' attempt at release. Other efforts are around, shifting the standard of those discretionary release hearings so that there's a presumption towards release. In pending legislation, in legislation that was pending last Congress at the federal level, that was sponsored by Senator Cory Booker and actually Representative Karen Bass in California, to allow a sentence review for people in the federal system. Because there is no parole in the federal system, it would apply across the board, regardless of offense, for people who served at least 10 years in prison, allowing a pathway back into court for sentence review. So essentially creating another remedy for release, because parole isn't a possibility at the federal system, and also to change the standard of what those release considerations are. So instead of a appointed board, it would be a judge. There would be a presumption towards release after so many reviews by the applicant for release. The first or second review, the individual would receive information in terms of what they needed to do to improve their subsequent review hearing, and there would be a rebuttable presumption towards release. So the shift is on the state to demonstrate why the person should not be released if they meet certain criteria, trying to shift away from the crime of conviction towards what the institutional record might be and who the person might be at the time of that review, 10 years into their imprisonment, or 10 years past their imprisonment whenever they choose to go up for a review. And then to also automate these review processes so the burden is not on the individual who may be suffering from a bunch of different stressors due to the trauma of imprisonment. So creating a new process for that. So I just say this to say that we are in sort of an emerging conversation around this effort to end life imprisonment, trying to expand parole eligibility, and then also look at these discretionary release hearings to shift the standard around them so that there's a presumption towards release, and then to also try to counter the implicit biases that might be disadvantaging BIPOC petitioners who are seeking release as well.
That's great. I mean, those are some great ideas. We need to do some more of that here in California, particularly when it relates to recognizing that the parole board has yet to make the kind of changes that we know they should, and whether we can find some better and more meaningful pathways into court to get courts to step in and right some of these wrongs. And I know that over the years, certainly it's been litigation primarily driven by people incarcerated, who are the main litigators in this particular area of the law, have pushed the parole board towards increasing the rate at which it grants parole, but we're still only at 16% of scheduled hearings resulted in parole grants. So we got a long way to go. Emil, I'm curious, and I think after this we may check in with Carlos to see if he has some questions from the audience. What recommendations you might have, Emil, for things we might do to eliminate or at least reduce the role of bias in the discretionary parole process, and what do you see as the barriers to getting there, if it's even possible?
Well, everything is possible. I mean, I think that we have to start from the presumption of possibility. Like I think that in this country, we're a lot of things, and one thing that it's hard to deny is we are the masters of production. We have created consumerism. We produce. We know how to produce what we want to produce, right? The question is, do we want to produce it, right? The prison system that we have is something that we have chosen to intentionally produce. The question is, do we want to produce something else? And ways that we can change the parole board. I mean, Nicole mentioned this a couple of times, but I think it's so important that it bears saying again, is presumptive release. I think we need to stress presumptive release, and Nicole has spoken at length about it, so I won't repeat it, but I just really want to stress the importance of that. The second thing is we need to put some serious thought into changing who our gatekeepers of the parole system is. We are having this conversation in a system that the entire nation has admitted is broken and is racially biased. Our parole boards are made up of all of the people who comprise this broken, racially biased system: district attorneys, former police officers, all people who have contributed to the problem that we're currently trying to solve are the people making the decisions on most of these parole boards. Another problem with parole boards is they are too political a position in the wrong way, and that is a governor of the state nominates a commissioner, which means he has his political career to consider when he's nominating people to be like parole commissioners. And so I think one thing that we need to do is it needs to stop being an appointed position and it should be an elected position. Because the person who the commissioner needs to be accountable to is the community it serves, not to the politician who's trying to get elected again or trying to go on and become president of the United States. And so he needs the votes of a large portion of the country who's racist. So I think that's a very important thing that we can do is like make commissioners electable and let the communities who the decisions actually impact have a say in who's making those decisions. And I think that, to your point, the biggest challenge to that is plain and simple, it's power. Like, if we're talking about a system that is rife with racial imbalance, then we're talking about racial oppression. And if we're talking about racial oppression, then we're talking about white supremacy, because racial oppression is just is just a means to an end. And if we're talking about white supremacy, then we are invariably talking about power, because we are talking about power structures. And so the resistance to change is a resistance to who has the power and who thinks that they deserve the power and who doesn't. And the idea that a parole commissioner would be elected by the very community that they're supposed to serve shifts a balance of power that will be resisted by the status quo, which is a white supremacist status quo.
Yeah, thank you. I mean, it just tells you, or tells me anyway, that anyone who feels like our current process and system is a fair one is telling you all you need to know about their position, about who they are, what their real beliefs are, and their commitment to this white supremacist structure that keeps Black and brown folks inside. I want to pause there. I want to first, thanks to both of you. I want to see if there have been any questions or comments coming in from the audience that Carlos wants to share with us.
Yeah, I think, Emil, right now, that last little bit from you really got folks riled up. Because I think
he does that sometimes. I count on it.
And I think the issue is that, so ChangeLawyers has been running little polls on our Instagram stories in the last week, asking people like what they want to know about this and what they want to ask you all. And one theme that keeps coming up is sort of the fundamentals. I think that right now the parole process is sort of where the DA's issue was at a few years ago, where people just didn't know that this is a thing. It flies under the radar for a lot of folks. So just to sort of go back to the basics, can you talk a little bit about the parole themselves? And this is for all of you. Can you talk about the parole board themselves? Like, are they, like, what is their racial makeup? Are they predominantly white? You touched on this already, Emil, but one thing we've gotten is why is it that progressive politicians who have the ability to theoretically appoint progressive board members don't, or like, do they? Does that even make a difference within the structure?
I'll kick us off a little bit. The California's parole board, there are 17 commissioners, and I think right now, last check, 14 or 15 of them have backgrounds in some type of law enforcement capacity, and it's been that way for as long as I've been doing this work, really. And they generally serve for 3 years, a minimum. They get appointed to 3-year terms, but they often stay for quite a few years beyond that. There's a decent racial mix, but it's overridden by the sort of philosophy, the law enforcement philosophy and training. I think most of us know that some of the worst and most racist cops may be Black and brown cops. So the race of the commissioner doesn't tell you much. The data tells you that if you're Black and you're being considered for parole, you're more likely to be denied. doesn't matter who the commissioner is. Now, the numbers are slightly different across racial groups among commissioners. And I think the work that Mr. Brodheim is doing right now is really going to shed a lot more light on that, and hopefully will inform some future appointment decisions for the governor's office. But I look forward to learning more about his studies. They're preliminary at this point, but that's my take on it.
Can I just jump in? So, I mean, there's a strategy in improving parole outcomes. There's an assumption that if people have different backgrounds, then that will improve parole release rates. I think that is honestly, that's a recommendation that the Sentencing Project, works to advance, and a lot of its reports and studies charting growth in life imprisonment and other factors leading to such a high number of folks sentenced to life in prison. Death by incarceration. And that is an active strategy that I've seen coalitions in Missouri and Virginia work on. And it is an untested and unproven strategy, whether or not focusing all that social capital on broadening out the backgrounds of gubernatorial appointees to the parole board in a particular state is actually going to improve authentic opportunities for release for people in discretionary hearings. But that is a strategy that, organizing campaigns and advocates are investing a lot of sort of social capital and time into. So we will see if successful, if the outcomes improve. I mean, I think, we have sort of a window into the possibility of that, given at this point, a decades-long project of working to diversify police departments, hoping for better outcomes, or diversifying other aspects of the legal system, hoping for better outcomes, and knowing that there's an underlying structure that the United States criminal legal apparatus reinforces. So no matter who works on behalf of the state, as part of that criminal legal apparatus, the disadvantages for Black residents, for Black and Brown residents are still there, unless there's an effort to consciously counter the implicit and explicit biases that show up every day from the point of arrest to the point of sentencing to the point of discretionary parole hearings. And that is all to say that it's not that there's not work to do in terms of engaging and critiquing the backgrounds of current parole board members and fighting for broader perspectives in terms of who is sat on boards, and hopefully that their backgrounds in social work or education or healthcare creates open pathways for empathy that makes it, discretionary hearings better in terms of the interaction and also the outcomes for people eligible for those discretionary hearings. But that it's not a panacea, and that and that at the end of the day, we have to work to counter racism, because if even people with a social work background that are working in a racist system, if they're not doing the day-to-day work to counter how racism shows up and how that may unconsciously reinforce it, then they're still working in a racist system that reinforces racist outcomes every day. And so there's just a lot of work to do around that, in addition to changing the underlying laws that contribute to disappearing someone to prison and these extreme sentences that subject people to a life imprisonment term to begin with.
Thank you so much for those comments, Nicole. I think you're right on point. We actually have in California, there's an Assembly Bill 1210 that is intended to bring a better mix of people from different backgrounds, not because it's going to solve all or even most of the problems, but because it's more likely to bring more empathy and understanding on the part of the parole board, so that their hearings reflect the kind of cultural competence and compassion that we really are looking for, so that they can better connect with the people who are applying for parole, and what we have without those sort of broad range of disciplines. And it's not nearly going to be enough. Like it can help, But as long as they're using the same regulatory parole suitability factors, we're gonna end up with the same problem that we have already.
Yeah.
So another thing that's coming from this conversation is, Nicole and you in particular talked about this earlier in the hour, how at every point where there's personal discretion, there's a possibility for things to go wrong. So, and I'll just put this question on the screen. It's going to cover your faces for a little bit, but you'll be able to read it yourselves. So what can we do about all these like inflection points where there is personal discretion in sentencing? And can you also give us a little like 101 on where those points exist in the chain?
Well, for discretionary parole, particularly given sort of where we started this conversation this afternoon, publishing demographic outcomes of people who are released by parole, particularly, in California, and this is a practice that should happen in every state, is a place to start. That is a practice that is assumed to impact the decision-making on the pretrial and sentencing side for judges and pretrial offices in states, that publishing that data creates transparency and shines a light on the individual practices, and presumably helps, just like we talk about cognitive behavioral theory for justice-involved residents who are, under some form of supervision or surveillance. That same sort of practice is thought to, change the cognitive impact of legal practitioners who are employing that discretion in those discretionary parts of the system. So that would be one place to start, given that this is sort of an emerging conversation and we're trying to build this out, is creating a transparency where that is automatically reported to shine a light on the practices of boards, with the hope of exposing any disparate outcomes and then creating, authentic ways to create equity in release decisions and in discretionary decisions. So that would be one mechanism to focus on.
Emil, you have anything on this one? I have a comment or two.
Yeah, I do. I think that one, to answer your question, like I don't know very many mechanisms of accountability to check personal bias and like racism in a parole hearing. You can take it. You can take a decision to court, and that can gain you various successes or not successes. But the thing about taking a case to court is you need a cause of action, right? And so one of the things that we could do for parole hearings is create a cause of action based on racial bias. Like California recently passed, I think it's Assembly Bill, let me see. It's Assembly Bill 2542, which is a great model that basically acknowledges, like, man, our system is broken and it's deeply impacted by racial bias. And they created a cause of action based on a conviction based on race. And whereas before, historically in our country, like the Supreme Court decided that, hey, we know our system is racist, but like, you have to prove personal racism. It's not enough for it to be structural. It's not enough for you to give me the data that it's wrong. And like this dissenting opinion in that case was like, you guys are essentially saying there's such thing as too much justice, that it would be too much work to actually do your job. And so California has like built on that, and they have created a cause of action based on race. And it says that, and it gives you, and it enumerates, right? Because there's a way that you can be very slick about race and be like, oh, it wasn't race. So they've enumerated, if you can prove any one of these things, you have proven that this was a conviction based on race, and it can be vacated. And we need the same thing for our parole processes. We need a legislation to create a cause of action so that when the people responsible to our community aren't doing our jobs, the community itself has something to arm themselves with and do the jobs that states aren't doing. They can take it to court, and they have a very clear cause of action to challenge a parole denial.
Let's do that. Y'all gonna do that in California?
There you go. There we go. See, all kind of things can come from these conversations. Two quick things about that. One, and I mean, I think you're talking about the Racial Justice Act, which is, there's an effort right now to make that retroactive, but we want to, as you said, we want to make sure that the ability to identify race as a factor in parole hearing outcomes is what's missing. Like that right now, it doesn't extend to parole hearing proceedings. So if someone is a victim of explicit racism in their parole hearing, there's no cause of action. There's nothing they can do. But I would also say that even where that exists at sentencing, or anywhere in someone's criminal legal proceeding, where we provide this sort of private, cause of action or way to get some relief. The question I really heard was about accountability. And I think there's a deeper systemic missing piece here. If we just can individualize the remedy and the relief, we never touch the system, right? Accountability is really about holding those decision makers, the people who run the systems accountable. Get them out of office. If there's some punishment they need to get, let's punish them. But at the very least, if they're perpetuating a system that's built on, that feeds off, that allows racism to exist on part of its deputies, its assistants, its commissioners, those people should lose their jobs, and we should appoint someone or elect someone who will uphold what fairness and justice really would require.
Do you believe in discretionary parole, or do you think it should be more automated?
Well, I think that parole should be much more predictable. The factors that decide it should be much more objective, and there should be much better access to the resources to be able to meet those objectives. And what I mean by that is, with it being totally discretionary, that two people could have no way to know exactly what they need to do to satisfy the parole board they can safely be released. Because the commissioners are going to be impacted by factors that those people really have no control over. Whereas if you have a sort of a prescription on the front end of someone's incarceration that says, here are the programs we expect you to complete, here are the things we expect you to do. And if we give people equitable access to do those things, and we interpret their success or lack of success with an equitable lens, these are all things that I don't even know how far away we are from these.
Yeah, we have many longer conversations to have.
But there's a process that makes it more objective, more predictable, that is hard to see from where we are right now, because it's so not even close. And I'm interested to see us move in that direction, but we're not even close at this point.
And that gets us to the Sentencing Project's long-term goal around having a 20-year max penalty for all sentences, which does not preclude a pathway out earlier, but to set the top at 20, so that all sentences are adjusted downward in the United States, which would follow more of a European model of sentencing, and hopefully really be a solution out of this mass imprisonment era that we've been in for the last 50 years or so.
And I want to add to the idea that how far away we are from some of the things that we're talking about. And I think that it's important, when you have that much distance between where you're at and where you're trying to get, that we acknowledge the limitations on our imagination. Right now, we live in a world where we have been circumscribed in this box, where most people believe that there's no other response to harm in a community but to imprison someone. So that's an imagination problem, because we were certainly doing other things before prison became like a boom, right? And so it becomes important to understand that that we are in a process of taking steps through experimentation, right? And so we're going to experiment with a lot of things. And every time we experiment, it's going to advance where it's going to change our vantage. And because we have at a different vantage in this journey, we're going to have a different and a fuller imagination. So it's not the goal to be like, what's the solution? This is it. It's like, no, 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 no. As we have said, we are a long way away, and we are not even positioned to like paint you out this grand solution that's going to solve all our problems. But we do know the system is broken. We do know we need to do something else. We need to move in another direction. And so we need to experiment ourselves to better vantage points. And the only rule of that, I would say, is we got to stop doing what we've been doing. That's why, like, diversity on the board may not be the answer, but we got to stop doing what we've been doing. Like, we got, like, and when I say diversity on the board, I don't mean, hey, let's get some other backgrounds on. I'm saying, no, for 20 to 30 years, this group of people has been in charge of this process, and they have created a nightmare. You are fired. It shouldn't be people with law enforcement backgrounds. We've tried that. We've tried it for 20 and 30 years. It does not work. It has only exacerbated the problem. So let's stop doing that. Like in this idea of we're experimenting our way forward so that we can figure it out, let's stop doing what doesn't work. Let's stop putting people with law enforcement backgrounds on boards. Let's just start there.
So we got the one question, Carlos.
But so many emotions in one question.
We're just getting started, but
I want to thank Emil and Nicole for being part of this conversation. I think you all add so much value.
Thank you so much
to this. The folks who registered are going to be receiving an email later today with the recording, and so it'll include also links to your works, because I think that folks will want to keep in touch. We had a lot of people in the comments asking about like the studies and all that you all were referencing. So thank you, Nicole, and thank you, Emil. I'm going to sign you both off right now. Thanks for joining us.
Can I just say thank you all, and please let's continue to have this conversation, because
absolutely,
it's not really happening in other circles, I think. No. So.
Okay. Thanks, Nicole. Thanks, Emil.
And Keith, I'll let you have the last word on this.
Well, this is, as you can see, this is the beginning of a conversation. There's a huge data gap. But what we see is very disturbing. We should be outraged. We have a growing percentage of our population who are incarcerated are subject to this system, and we need to know if there are biases, and if there are, we need to fix them. If that means change the decision makers, we do that. But it definitely means we need to change this process. We need a new one.
Absolutely. So thank you, Keith. Thank you to our Change Lawyers family and our Uncommon Law family, and anyone else out there who joined us. Join us for part 3, which is going to happen on May 12th. So Keith and I are going to sign off, but I'm going to put a banner on the screen with information on how you can register for the 3rd and final part in this event series. That's going to focus on decarceration for all. Like, everyone should come home. So thank you, Keith. I'll see you later.